Hey, everybody, welcome and Merry Christmas. We are the week before Christmas. We're going to be taking next week off. We will be back on January 3rd for our next True Crime Wednesday. But I have so much to tell you and some really exciting things to share. And so I'm just going to take a minute and let our live viewers catch up, and we will dive in for chat. So one thing that I wanted to tell you all is I just saw a Twitter post on Dateline NBC, and it is Keith Morrison reading the Grinch. And it is absolutely adorable. The only thing better than him reading The Grinch is him growling loin fire. So if you get a chance, catch that because it's really cute. Welcome, everyone. Let me just introduce myself in case you're new to the channel. My name is Lori Hellis, and I am a retired criminal defense attorney with about 27 years of experience. And I'm writing a book about the Lori Vallow and Chad Daybell case. And to that, I want to share something I'm super excited about. Voila. This is a draft of our book cover. It will have some minor tweaks, some few changes probably to the subtitle that might move around a little bit, but this is the basic outline, and I am absolutely thrilled with it. I think it's beautiful. I think it evokes such a mood. I love the color, and I love that this is JJ's tree. This is the symbol of so many things that are about this case, the innocence of it, the sadness of it. So anyway, I'd love to hear your thoughts, either in our chat, or you can email me and drop your comment in the comments below if you would like to, because I'm super excited about it. My agent and my editor our editor is just finalizing some of the final tweaks on it, and then it will be presented to Simon & Schuster, who do all of Pegasus distribution. So we're really excited about it. The chapters have all gone out to my beta readers. They're supposed to have stuff back to me by the end of the week. And then I am planning to have chapters to our editor in early January. We'll be updating some chapters. We will be updating some chapters once the 2 April trials happen, and then we will be going to press. So I just noticed in the chat, this lovely, that's my daughter, is in the chat tonight. Hi, babe. Just wanted to say hi to her, even though she hasn't changed her ID yet because she has a different last name now. But anyway, I'm looking forward to being in LA next weekend, or this weekend coming up, and heading down there to spend Christmas with my family. Super grateful that my wonderful house sitter is going to be holding down the fort and taking care of the creatures while we're gone. I don't know, I couldn't do it without her. So I have a couple of other things I wanted to share. First of all, we have finally done the drawing for the quilt that you see behind me. That is the True Crime Quilt Guild quilt that we all did together. And that goes to Kathy Watson. So Kathy, if you are watching, DM me with your address. If not, we'll email you, and we'll get back in touch with you and get the quilt out to you next week. Thank you so much for everybody who bought a ticket, because we were able to make a nice donation to the Center for Missing and Exploited Children. So thanks so much for donating. All of the proceeds went to the Center for. You'd think that I'd had an extra bad Santa tonight, the way I'm stumbling, but all of the proceeds went to the Center for Missing and Exploited Children, and we were happy that we were able to make that donation. Well, I just wanted to remind everybody that January 3rd will be our next time we all meet together, that we are taking next week off to spend Christmas with our family. So also, I want to thank Jen tonight. She is pitch hitting, I think is the right term for Michelle, who couldn't be with us because she's under the weather. As you all know, Michelle is in the midst of some pretty intense chemotherapy right now, and she's kind of minute to minute with how she's feeling. So please send her all your good wishes. Please remember that all of your super chats, all of your PayPal donations, the links to PayPal are in the description below. All of those donations go directly to Michelle, and we appreciate it. I appreciate it. I know she appreciates it more than you could imagine. So if you have got a little extra to share, please be generous for our Michelle. Well, let's dive in, because we do have a few things to talk about on Vallow Daybell to start with. Then we have some other really big news in the Ruby Franke case. We've got Adelson to talk about and a lot more. But let's start out with Vallow Daybell. A couple of things happened to just yesterday, which I thought were wonderful and important. First of all, there was a stipulation to release Tylee. And I don't know what arrangements have been made for her. I know that at one point, Kay and Larry had hoped that they would be able to lay the kids to rest together. I'm sure that they have been talking to the Cox family and attempting to work out some details, because I think everyone would like them to be together. So that was good news. The other thing that was interesting is that the judge set a monthly motion hearing date so that they would have a date on the calendar to hear any pending motions. So we don't have any motions pending, and the judge vacated the hearing that was set for the 28th. So there won't be another hearing until January. In the meantime, there was a decision, a formal decision that was issued on Chad's motion to strike the death penalty. Now, Chad had two bases for wanting to strike the death penalty. First of all, he wanted to strike the death penalty because he argued that the state said Lori Vallow was more culpable than he was, and that she didn't get the death penalty, so he shouldn't either, because it would be unfair under the due process clause of the Constitution. The judge threw that out, said, no, that is, the case law doesn't support that. The law doesn't support that. And we believe that, and the judge was quick to point out that the reason why the death penalty was taken off for Lori had absolutely nothing to do with her level of culpability, or it didn't have anything to do with the factual basis of the case. it was entirely granted, dismissing the death penalty to punish. Thank you so much, Kathleen. You are always so generous and so kind. Thank you. So what the judge pointed out was that the death penalty was taken off the table for Lori purely as a punishment to the prosecution, for the prosecution not giving out or not providing discovery as they were required and missing discovery deadlines. So the judge was quick to point that out, said Lori Vallow's culpability or the relative culpability of either of them had absolutely nothing to do with the court's ruling. So then Chad's attorney said, well, if you don't grant it on that ground, you have to grant it on the grounds that the death penalty is cruel and unusual and all of the usual challenges that defense attorneys make to the death penalty. And the judge pointed out that within the state of Idaho, the death penalty has been found to be constitutional, that there's absolutely no basis for a finding at this point that it is unconstitutional. And so the judge denied that motion as well. So I'm going to take down the book cover. I'm sure everybody's had a chance to enjoy it. And I do want to say that although I usually try and avoid anything with ice in it because it makes noise in front of my microphone, I am having a bad Santa tonight. For all of you who know me, you know that this is one of my favorite holiday drinks. So I'm going to put that up for a minute so everybody can think about their own version of a bad Santa. So there were some other developments that happened in the Arizona piece of Lori's case. In Idaho, they filed a waiver of the Idaho Criminal Rule 35. And this is basically very procedural, but it's in the court docket, so I wanted to point it out. That what they're saying is under Rule 35, a defendant can file a challenge if they believe that a sentence was illegal or was improperly brought by the court, imposed by the court. And they filed a waiver to the right to challenge the sentence, meaning that there was no basis for them to say that the judge's sentence was somehow illegal or improper. Now, the Idaho, let me see. In Idaho, the judge has set a deadline for the Idaho transcript to be finished in order to move forward with the appeal. That transcript is due by the 8th of January. So we'll see whether the clerk can get that done or whether they'll be asking for another 30 days. We know that has got to be a voluminous transcript. I mean, these folks are going to be transcribing every word that was said during that 6-week trial. So we know that it's going to take some time to get that done, and I am certain that that they may possibly need extra time. But right now, it's set for the 8th of January. And then in the Arizona case, she has an initial pretrial conference set for the 18th of January. And it was interesting that the court also issued an order sealing a lot of documents and ordering a gag order, which is a little interesting because the Chandler and Gilbert police already both did huge data dumps based on FOIA requests from earlier, sometime last year. So it's kind of like closing the barn door after the horse is out. Now, there were substantial parts of those reports that were redacted, and presumably we won't see those until she goes to trial. At this point, we don't know whether she will go to trial in April as is anticipated, but she didn't waive her speedy trial in Idaho, and I don't anticipate that she is going to um, waive her speedy trial in Arizona either. I'm going to take down the Bad Santa recipe. However, it is on our community page on YouTube, so you can find it there if you didn't have enough time to jot it down. So, moving on to Adelson. As you all know, Donna Adelson is in jail. She was arrested trying to leave the country. There's a lot of new information coming out because there were hours and hours and hours of jail phone calls between Charlie and Donna before Donna was arrested. And some of the most interesting ones, I'm not going to post them here. Gigi at Pretty Lies and Alibis has done a complete download of all of them. You can listen to them there. There are several other platforms that have also, YouTube channels that have also downloaded them. So they're out there, and there's no sense taking up your time and our comments with those. But one thing that was very interesting was there is a telephone call between Charlie and Donna. And what Donna didn't realize is that if you don't hit end call, the recording continues, the jail recording continues. And so even though Charlie got disconnected, Donna continues. She doesn't want to end the call because she thinks Charlie might come back on. And there are financial charges made each time you connect. So she doesn't want to cost Charlie a connection if he comes back on. And there are several places in the calls where Charlie fades out because of a bad connection and then comes back in. So she stays on the call, but she's talking to other people that are there. She's talking to Harvey, and she's talking to a couple of other people who are obviously friends of hers that are there in the background. And she talks with them. They are people who have been helping them get their financial affairs in order and set up trusts and those sort of things for the grandchildren, including Charlie's son, as well as Wendy's boys. And they are folks who have been helping out take care of stuff in the background. She then has a conversation with them about the fact that she's tired. She's talking about how she's had a good life, that if they can't leave the country, she and Harvey will end their lives. And it's sad and it's troubling. And I think, she seems extremely resigned at that point. Then we know that she's arrested trying to leave the country with Harvey, her husband, and they literally stopped her in the jetway as she was boarding an airplane with a one-way ticket to Vietnam, which has no extradition treaty. Some of the other interesting comments are the fact that it appears that there has been a real fracture in their relationship with Wendy. Wendy apparently has been declining to respond to any communication with them. And she keeps saying, "I'm not allowed to talk about the case. Please contact my lawyer." When Donna contacted her lawyer, the lawyer said, "I didn't tell Wendy that at all." So it appears that Wendy is trying very hard to distance herself from her parents and the continued issues going on with the family. It doesn't appear, from my opinion, that Wendy is going to be able to distance herself from her potential involvement in the death of Dan Markel, her former husband. We'll see what happens. But for now, it seems like there's a fracture happening there. And if there is a fracture, I think it becomes more possible that that they could turn on Wendy if she is not sticking with the family and not within the circle of trust. Then I think there's a problem. And I think that maybe we're seeing some cracks occur in that relationship. And that could very well lead to Donna and Charlie turning on Wendy. Particularly Donna. Charlie, of course, has already been sentenced. He's already been found guilty. He's already been sentenced. So whether or not he can make his situation better by turning on Wendy is a little bit questionable, but certainly Donna can improve her situation probably remarkably by turning on Wendy. So that is interesting to keep an eye on. One of the things that Donna says is that she has talked over. Now, remember, Daniel Rashbaum, who was Charlie's criminal defense attorney, initially was the attorney for Donna and Harvey. So he's got a little bit of a conflict issue. It doesn't appear that he is continuing to represent Donna, but it does appear that he is been sort of walking a tightrope in talking with her about Charlie's case. So interestingly enough, at one point, Donna tells him that they are tells Daniel Rashbaum that they are considering leaving the country. Now, remember, at this point, Donna has not been charged. She is an unindicted co-conspirator, but she has not been charged. And Daniel Rashbaum does not have an obligation to report her intention to leave the country. So Donna says, I talked to Daniel about it. He seems to think that it might not be possible, that they may intercept us before we leave, but it's worth a try. Now, a lot of people have interpreted that as Daniel Rashbaum saying it's worth a try. I didn't hear it that way. I heard Donna saying it's worth a try. I don't believe that Daniel Rashbaum gave her the advice that it was worth a try for them to try and leave the country. So, but there are a lot of questions about Rashbaum's involvement, whether or not it presents a conflict at this point, and whether or not him encouraging them to leave the country and or get their affairs in order in advance of a suicide, it poses an ethical problem for him. So one of the things that I thought was really interesting is Charlie and Donna talk at length about him being in observation. So he's taken out of the courtroom after he's found guilty, and he is not put back in his usual cell in his pod. He is moved to an observation cell, and he is told that he will be there at least 72 hours until they're sure that because of the verdict that he won't hurt himself. And so he's talking to his mother at length about what the restrictions are being in an observation cell, what's going on being in an observation cell in Tallahassee, and having all of these sort of in-depth discussions about what you can and can't do when you're in an observation cell. It's clear that Donna has done some research. She's gotten online, she's asked some questions, and she's really pretty conversant in why he's in this observation cell and what it's going to take for him to get out and get back to his own cell in his own pod, which makes it all the more interesting when you watch her hearing having to do with her being in an observation cell. Now, remember, law enforcement has these taped conversations between she and Charlie, where she is talking in depth and very specifically about ending her life. So law enforcement clearly has a reason why they should be concerned about her safety and whether or not she is going to attempt to hurt herself. She is in an observation cell. She is wearing a garment that that is designed to protect her from injuring herself. And so her complaints that she's in a cell and she doesn't have regular clothes, which she interprets as she's in a cell and she's naked, which is not the case. She's got this garment on, and it is a protective garment, but she doesn't have clothing because they've taken it so that she can't use it to hurt herself, use it as a ligature or something like that. So I thought that it was interesting that, knowing what she knew about Charlie being in observation and the conditions that he was in, that she was complaining about the conditions that she was subjected to when she was moved into observation. Now, when she was in Miami, they had a psychologist who assessed her, or a psychiatrist who assessed her and cleared her to be moved into general population. But when she was moved to Tallahassee officials said, we don't feel as secure or as convinced that she's not going to try and hurt herself. So that was the issue. And so as far as we know, she is still in that observation section. Oh, I got to answer a question from Squeaky Wheel. The Bad Santa drink mix calls for vanilla vodka. I don't have any of that, but I have some 100 proof vodka on hand. Can I use that and maybe put a few drops of vanilla extract? That sounds like that would work great. I also have heard or seen online of folks using vanilla Crown Royal instead. Now, Crown Royal has started coming out with some flavored versions like flavored vodka. But, you know, I don't think the vanilla vodka is really critical, because you do have the Myers rum with all the spices in it, the rum chata, which kind of has a creamy vanilla flavor anyway. But you can't leave out the Fireball, because that gives it the cinnamon kick. So, but that was a great question, and I thought I'd answer it as long as I saw it go by. So I'm trying to give Jen a little bit of help as I go along, because I know that she's got lots of questions coming up. She is, I see in the chat, she is marking questions. So when we get to the Q&A part in a few minutes, we'll be ready to take questions. So the next case I want to talk about is Ruby Franke, because we had a really big development in that case. Ruby Franke entered a guilty plea to 4 felony counts of child abuse. And it was very interesting. I know a lot of people, and trigger warning, y'all, if you're sensitive about issues having to do with children, please pop out. Because we are going to talk about some of the allegations that she admitted to. Now, when a person enters a guilty plea, they have to stipulate, or the state has to present facts that support their guilty plea. So in this case, in her plea petition, in the document she signed, she actually listed the facts that she was admitting to that support the guilty plea. So that evidence was very clear. She admitted that she abused her children, as well as allowed Jody Hildebrand to abuse them. So that was a little bit different than just blaming I left my children with Jodi Hildebrand and she abused them. She admitted in participating directly. Some of the things the children were subject to were lack of food, being fed very simple food like rice and chicken or beans and rice, being having to work outdoors in the sun, and as a result getting very badly sunburned, working outside without any water, working outside for long hours of physical labor. They also were subjected to having their wrists and ankles bound to the point where the ligatures cut into the skin, and then they simply just covered the injuries with duct tape to protect the injuries and put the ligatures back on the handcuffs or the restraints. There were several other things that were in there that were probably not as significant, but clearly these were children who were bound, restrained, not fed, not given water, and forced to do hard manual labor outdoors in the heat and the sun. They were subjected to psychological abuse, being told that they were evil, that they were possessed by Satan. Nothing that anybody should be particularly surprised about if you have heard any of the interviews that were done with Jodi Hildebrandt's niece, Jessie. So very much the same as what she described. And but Ruby Franke admitted. Now, there's a couple of interesting things that are in her guilty plea. One, her lawyer confirmed for the court that there is no discussion about anything other than prison time. So there's no discussion that she is going to get off lightly with with a local jail sentence or with any kind of probation and no prison. So the judge made very clear that the plea agreement entertained and decided that she would be receiving prison time. What was also confirmed was that she will testify truthfully against Jodi Hildebrandt, and that the sentencing will be left open, and the judge will have complete control over what the sentence will be. Now, the sentence, and that the sentences will be consecutive, one after another, and not concurrent. So we know that she is going to get 4 separate consecutive prison sentences. What we don't know is how long. The potential sentence could be anywhere from 1 year to 15 years. Is she going to get 1 year? Absolutely not. She's going to get something more than that. So a lot of people have been sort of trying to predict, well, how much time do you think she's going to get? I think she's going to get somewhere between 12 and 15 years. And that is going to assure that her children have all reached adulthood, and they are all have had plenty of time to receive therapy and to be able to move through that healing process. So that's my prediction. I know there are a lot of other people who are saying maybe 5 to 7. I don't think so. I think we're going to get somewhere between 12 and 15. That's just my gut and my experience. Now, I'm not experienced in Utah, so I can't speak to Utah sentencing matrix and have a feel for what Utah judges do, but that's my prognostication. So we'll see whether who's right on that one. I think if she gets any leniency, it is going to be because of her agreement to testify against Jodi Hildebrandt. And I think Jodi Hildebrandt has a plea coming up I think it's the 28th of December, but it could be into January. I didn't write it down, and now I don't remember for sure. But if anybody else knows that, put it in the chat. I think it's the 28th of December. She's got a plea hearing. She's got a hearing set. Now, Ruby Franke's hearing was originally, oh, somebody just said the 27th, so I was close. Ruby Franke's hearing was initially scheduled as a waiver hearing for her to waive a preliminary hearing. We know that that is going to be coming up for Jodi Hildebrand as well. So I would not be at all surprised if we see a plea for Jodi Hildebrand as well, because I think a trial for her is going to be very dangerous. If Ruby Franke is going to testify against Jodi, if, as I suspect, Kevin Franke is going to testify against her as well, then I think she's got a lot more liability, and I think that it would be dangerous for her to go to trial. She could very well be spending the rest of her life in prison if she goes to trial. So smart money will be on her entering a plea in December. Now, in Ruby's case, the judge has ordered a pre-sentence investigation. We know about those because we saw one in Lori Vallow's case. They're very common in these sort of cases having to do with complex felonies. And so what'll happen is the adult parole and probation folks will complete a pre-sentence evaluation. And that looks at whether or not her criminal history in the past. We know that this is first-time offense for her. The seriousness of the charges, her psychological makeup, medical history, educational background, a number of factors. If you recall, Lori Vallow declined to participate, and it was still 100 pages long or more. So they're very in-depth and very lengthy, and they take time. So the judge has set Ruby Franke's sentencing out until March. The other reason for that, I think, is to allow Kevin Franke to continue to work through the family court process, because I think he is trying to regain custody of the younger children. So we don't know for sure where the younger children are. I suspect they're with the oldest sister, but I'm not sure. I just know how child welfare system works, and they're undoubtedly with family. Could be with Ruby's sisters. So Ruby will be sentenced in March. In the meantime, I think Kevin Franke is working hard with the family court and child welfare, because I think he wants to get the children back. His filing for divorce from Ruby was a huge step in that direction. So I think we're going to see him regain custody of the children with some oversight from child welfare, who are going to require that he make sure that they get lots of therapy, that they get all of the help that they need, and that they have plenty of time to decompress and heal before they have to see Ruby, or before they know anything about what's going on with her, and before she has an opportunity to have any contact with them. I'm sure it will be a lengthy period of time before she's permitted to have contact with them. So we have a few little developments in the Kohberger case. So let's run through those. Recently, the judge denied the dismissal of the case because of the challenge to the grand jury. This was one of the last issues that was outstanding from that whole spate of motions that the defense filed 2 or 3 months ago. So one of those motions had to do with them challenging the grand jury. Now, grand jury challenges are typical in felony cases. It is typical for defense attorneys to scrutinize the charging document, the process of the grand jury, and to make sure that all of that was done properly. It's practically malpractice not to do that. So every defense attorney is going to be scrutinizing the indictment, making sure the indictment actually says what their client's being charged with, making sure that the grand jury process was observed, all of those things. Now, one of the challenges that Kohberger's defense team made was saying that historically, sometime in the way back past in Idaho, that the legislature had intended that this legal standard for grand juries was supposed to be beyond a reasonable doubt. Every grand jury is only deciding whether or not there is probable cause. And we all know that that is a very low standard. That essentially is them saying it is more likely than not, so 51%, it is more likely than not that the crime was committed and the defendant is the person who committed the crime. That's the only thing a preliminary hearing or a grand jury decides. So it was a stretch for the defense to say, hang on, back in the dark annals of time, the legislature that wrote this statute and created the Idaho Constitution intended that legal standard be beyond a reasonable doubt. So the judge took it under advisement, and it issued a very detailed and cogent memorandum finding as to why it was not as the defense proposed. So the first page says, I've denied the motion, and then goes on for another 12 pages to explain the legal reasoning. So for those of you who are really interested in the legal reasoning behind things, all us law nerds, or as another podcaster calls them, I always say law wonks. If you are interested, Emily D. Baker, that's the name I was trying to come up with. If you're interested in that 12 pages of legal reasoning, you can take a look at that. Now, Kohberger does not have a new trial date yet. And the reason for that is because the judge still has a couple of outstanding issues. If you recall, one of the things the defense demanded was that the prosecution hand over all of the information having to do with the genetic genealogy. If you recall, they used genetic genealogy to identify Kohberger's family and connect him back to the scene of his family's home and get a warrant to search the garbage there. The judge ordered that the prosecution needed to provide at least some of that information to the defense. And the prosecution said, well, how do we know what we need to provide? And the judge said, send it all to me. I will review it in camera. And in camera, Latin words again, means in chambers. And I will review it and determine for you what information I believe you must turn over to the defense. So the deadline for doing that was December 1st. There is a filing that shows that it was submitted on December 1st. Now, judges are busy people, and I'm certain that it is going to take him a while to go through all that information and determine what needs to be turned over to the defense. So I would anticipate we will see something after the first of the year, because the holidays are also a time that lots of people within the court system take time off. So I think we will see something in January, perhaps, determining what information needs to be turned over to the defense. Once that's done, then I think we will see a new trial date set. But at this point, Kohberger has waived his right to a speedy trial, and so I don't know that we're going to get a trial anytime soon. We could see a trial maybe in the fall. The other thing that's been going on is this ongoing issue of whether or not to demolish the house where the crimes happened. Initially, the defense and prosecution both said, we've gotten everything we need out of it. You can go ahead and demolish it. The school that owns the building, the landlord who owned the building donated the property, building and real estate, to the university. So the university has been responsible for providing security, making sure that it's maintained, all of those things, in order to make sure that the property is secured until it can be demolished. And there have been several dates at which the property was going to be taken down, and then for one reason or another, it's been stayed. So some of the family members have said they don't want the house demolished until after the trial. And while I understand the reasoning, I'm not really sure that it is going to be helpful for them to maintain that property until after the trial. It's certainly possible. Now, we saw in the Murdaugh case, think about what we saw in the Murdaugh case. We saw lots of pictures, lots of diagrams, lots of descriptions, all of those things of the crime scene. Later then, the defense requested a jury view. Now, in my opinion, I think a jury view helps the prosecution. I don't think that the defense ever gets any favors done by getting a jury view. Here's the reason why. Standing in the space where a crime occurred hits differently. And so I believe that taking the jurors out to the Murdaugh crime scene and letting them stand in the room where Paul was shot, letting them stand in the place where Maggie was shot, letting them understand viscerally the spatial comparisons, I think helps the prosecution. I don't think that it helps the defense at all. Now, this may very well be why the family of the victims want the house maintained. But I'm not sure that there is a big enough gain. I don't know that the prosecution is going to say there is enough of a gain to justify demanding that the university continue to bear the cost of keeping that property available, unless we know that there's going to be a trial sometime soon. We don't have a definite trial date, and we don't know when that might happen. So I can see both sides of it. I certainly can see why the victims' families might want to keep the house intact. I can also see the point from the university standpoint. I don't believe it does the defense any favors, so I don't know why the defense would be continuing to object to it. But it will be interesting to see what happens and whether or not they're allowed to take that house down, the building down. So we have a couple of other cases that we have talked about that I wanted to at least touch on before we start taking questions. So the first of those is Dee Warner. Now, a lot of you have asked me about Dee Warner's case, and it has some unique issues. For one, Dee Warner was married to Dale Warner. She had a fair amount of assets that she brought into the marriage. There was suspicion that Dale was abusive, that there was domestic violence going on, and Dee disappeared. Her children then, for the better part of a year, have been trying to get the court to declare her dead so that they can pursue a wrongful death suit against Dale Warner. They were very frustrated with the fact that the state had not ever brought him up on murder charges. One of the places where one of the impediments to bringing murder charges was that Dee's body has never been recovered. So now, we've talked before, no body murder cases are possible, but they are difficult. So the prosecution always faces an uphill battle in prosecuting a no body case. Now, about a month ago, Dale Warner, maybe a little more than a month ago, Dale Warner was arrested on murder charges, and he is being held on $15 million in bail. His bond was actually lowered from 20 million. So, but he is in custody. There is a preliminary examination, which sounds to me like it is similar to a preliminary hearing in March. And in the meantime, he's being held on all of that bail. Dee has been missing since April of 2021. And I think now that he is in custody, I think that they are combing through his GPS data and his phone data and anything else they can find to see if they can figure out where her body is in the meantime. So I'm certain that that was a huge relief to her family and her children, because now there may very well be a basis for a wrongful death suit as well. And it's evident that both she and Dale had substantial assets. So it's very possible that they could be able to bring a wrongful death suit and also be able to protect Dee's assets from him inheriting any of it. Of course, now that he's been charged, that's going to be more complicated because of slayer laws. So next, I want to talk about a couple of Idaho cases that have been of interest to folks. One of them is Major John Kaler. Major John was this guy's first name, and it was all one word, Major Jon. He recently pled guilty to 4 counts of second-degree murder. We've talked about this case before. So the facts of the case were that he lived in a 2-story apartment building, sort of like a 2-story duplex. And the people who moved in downstairs were Kenna Gardepee, her father Kenneth Gardepee, and Kenna's 2 children, Devin Smith, age 18, and a boy who is identified as A.S. Smith, presumably age 16. And what had happened was Kenneth had just graduated from high school, and the Kaler, there are many K names in this case, Major John's wife, had expressed concern about the fact that Devin Smith was behaving inappropriately toward their young daughters. They would be out in the yard playing on the trampoline, watering the garden, and he would be standing in the upstairs window undressed and touching himself and behaving inappropriately, intentionally to get the girls' attention in front of them. So they called the police. The police weren't real quick to do anything about it. They confronted Kenna and Kenneth, her father, about it, and they were all a little bit sort of unconcerned about it. It's my understanding that that Devin Smith, who was the perpetrator, had some developmental issues and was a little bit hard to control. So this went on for a couple of weeks, with the police not really taking an interest and the Gardepees not really taking any affirmative action to protect the young children and to rein Devin in. And Major John came home from work one afternoon. He walked in the house. He strapped on his gun. They went outside to water the garden, but he put his gun on first and walked out. There was a confrontation between he and Kenna, and Kenneth came out, and there was a confrontation between the two of them. And Major John admits that he shot each of them in the temple and killed them both. He then went inside their apartment, hunted down both boys, including the 16-year-old, and killed both of them as well. Each one of them was shot with a single bullet, with the exception of Devin, who was shot multiple times while he was on his knees. And Major John admits that at one point he had to reload and put a new magazine in the gun. So there was a lot of intentionality associated with it. It was very evident why they charged him with first-degree murder. They were seeking the death penalty. There was a negotiated sentence in which they modified the charges to second-degree murder, and he pled guilty. That's a huge benefit for a number of reasons. One being that his own children were witnesses and likely would have to testify. So it is a blessing that that outcome was reached. He has not been sentenced, but with the death penalty off the table, there's no doubt he will be getting life in prison without parole. So, and then the last case, and I want to give you a serious trigger warning here, folks. If this case involves mental illness and involves the abuse of a child, a very young child. So please, if this is not something that you are up to hearing, say goodnight, or mute us while we talk about this portion. And then we will get to questions and answers. So this is the case of Jeremy Best. This is an Idaho case. Nate Eaton from East Idaho News covered it very extensively. It happened in eastern Idaho. A man named Jeremy Best was having pretty serious mental health issues, was clearly having mental health problems. He confronted his former wife, and police were called, and they kind of chased him off. They ran him off, but they didn't arrest him. He came back the following day and shot and killed his former wife, who was pregnant, and took their 1-year-old child. He was later found on a back road. His pickup truck was found on a back road. He was found naked in a sleeping bag by the side of the road near his truck. And the little boy Zeke was discovered inside the pickup truck. Up until his indictment was released, I think we were under the assumption that the little boy had died from exposure because it had been very, very cold back there. It had been well below freezing consistently. And he was in the pickup truck. But the indictment reveals that the child was killed with a knife. So, and indicates damage to his neck. That's hard stuff. At this point, all of his victims, I mean, his poor wife's family is having to deal with the death of their daughter, their future grandchild, as well as their living grandchild. So it's a really hard case, and he is clearly desperately mentally ill. the state has and defense have already agreed to a competency hearing, and there is absolutely no doubt that he will be going to the state hospital for some level of restoration. It's very unclear at this point whether or not it is even possible to restore him. So, and remember that there is another case, little Michael Vaughn out of Fruitland, Idaho, that we've talked about as well. And the woman who has been implicated in that case was charged, and later those charges were dismissed because mental health officials said they didn't know whether she would ever be able to regain competency to stand trial. Now, also remember, however, that in Utah, in the kidnapping of Elizabeth Smart, Wanda Barzee and David Brian Mitchell were both declared incompetent for some lengthy period of time. Mitchell actually was about 8 years before a psychiatrist spent enough time with him to say, no, he's malingering, and he was then finally tried and convicted. Wanda Barzee spent 7 or 8 years in a mental institution. She was actually incompetent, was restored to competency, was also tried and convicted. So the fact that someone is in a mental health facility for restoration for some extended period of time doesn't mean they'll never be competent again. But in the case of those lengthy restoration efforts, it's more likely the prosecution is going to dismiss the case. And then if the person becomes competent, the state hospital has to notify the court, because there is a commitment order that the judge has to enter an order finding the person competent and vacating the commitment order. So the state and the court will know if, in fact, either one of those folks become competent. But for now, I think we'll wait to see whether or not they are able to restore Jeremy Best. He is clearly very severely mentally ill. So that wraps up what I wanted to talk about tonight. And I'm ready to take a few questions. So if you haven't had a chance to make yourself a bad Santa, now be a good time while Jen gets some questions lined up. Sorry for the ice rattling, but Merry Christmas. Kavita Diva, isn't taking a plea somewhat illegal? Not really sure in what way, but taking a plea is not illegal. Probably at least 90% of criminal cases resolve with pleas. If they didn't, we would be backed up for years in court. There would be no way that judges could dispense with the cases that would be backed up. So generally what happens is the prosecutor has discretion in how and what to file. Thank you very much, Diane. And the prosecutor decides what charges the facts of the case warrant, and decides what crimes will be charged. The prosecutor also then has the discretion under the law to determine whether or not a negotiated settlement is in the interest of justice. So the prosecutor has a heavy responsibility to weigh the case and to decide whether justice would be served by a plea. Now, many times justice is served by a plea because we have witnesses who are vulnerable and who would have to come and testify. For example, Ruby Franke's children. For example, family members who witnessed a terrible shooting in Major John Kaler's case. So it is judicial economy, meaning that and general economy and good stewardship of taxpayer resources to resolve cases that can be resolved without a trial. Because we know that trials are expensive. Look at Vallow Daybell. They'd spent $3.7 million before that trial ever started, and easily another $1 million just on the trial. So it is going to trial is a very expensive proposition, even if the case is not a high visibility, complex case requiring weeks and weeks of trial. So it is common for prosecutors to offer pleas and to allow someone to plead to perhaps a lesser included offense, or to come up with a negotiated settlement for an agreed to amount of time for an agreed to sentence. Usually that is done in return for a person's cooperation in continuing to prosecute other co-defendants or other people involved in the case. So plea agreements are not illegal and are very common and are, I would say, more common than trials. When you get to a situation where the defendant really has nothing to lose because the death penalty is on the table and the prosecutor is not willing to take it off the table, or whether the max penalty is on the table and the prosecutor is not willing to compromise, then your client doesn't have anything to lose by going to trial. Many states have mandatory sentencing matrices. Matrices is the proper term. What that means is if a person is convicted of a particular crime, the only option the judge has is to sentence the person to the mandatory sentence. So, for example, in Oregon, there was a ballot measure on the ballot that instituted mandatory sentences for certain violent crimes. Under that ballot measure, which became law, we all still call it Measure 11, but it is the mandatory sentencing law in Oregon. If a person receives a conviction for X crime, the mandatory sentence is X, and there is no latitude for a judge. So, for example, if a person is convicted of arson in the first degree, there is a mandatory 7-year sentence. They don't get time off for good time. They're not eligible to participate in any programs in prison. They serve their time day for day. And that is the penalty for being convicted of a very complex violent crime. But if the prosecutor decides, well, I will only charge you with arson in the second degree, and if you'll plead guilty to arson in the second degree, then the prosecutor has more leeway in recommending a sentence because that isn't subject to the mandatory sentence. So it gives prosecutors a tremendous amount of power. A lot of people argue that it takes the decision out of the hands of experienced judges and puts it in the hands of prosecutors who could be right out of law school. Now, typically, prosecutors who are prosecuting complex felonies are not just out of law school, but it is potential. So a lot of people have been critical of those mandatory sentencing schemes that came in this sort of early to mid 90s, when we really had a political and social sort of pendulum swing in the direction of being tough on crime. We've seen that pendulum swing back, and we've seen a lot of states do away with their mandatory sentencing matrix and go to an indeterminate sentencing scheme. Now, in the newsletter archive, you will find a blog having to do with sentencing schemes and indeterminate versus determinate sentencing schemes, where I get way down in the weeds on what those look like. Because Arizona and Idaho are two really good examples. Idaho has indeterminate sentencing. The only time there is a determinate sentence is if you have filed a death penalty case. If a notice for death penalty has been filed, then the only two possible sentences are life without the possibility of parole or the death penalty. Otherwise, all other Idaho sentencing is determinate, meaning that there is a period of years the court can impose before you are eligible for parole, and that is up to a judge. Conversely, or on the other side, in Arizona has determinate sentencing, meaning that they have a sentencing matrix, and if you are found guilty of a particular crime, you get this sentence. So, for example, second-degree murder there, first-degree murder is potential death penalty or life without parole. Second-degree murder is the potential for is life with the potential for probation for parole after 25 years. I take that back, after 12 years for second-degree murder. So it's just a different way of looking at sentencing, and it does shift some of the authority and the power away from a judge and to the prosecutor. So, good question. That was a very long-winded explanation, but I think we can move on to the next question. Hi, tennis girl. Question: what type of evidence could Charlie provide? This is Charlie Adelson. If he decides to flip on Wendy, seems like he'd need to back up what he says. Well, undoubtedly, he would have to back up what he says. He would have to be able to give very specific details about when and where he and Wendy discussed the plan. I don't think it's as likely that he will turn on Wendy because he doesn't have as much to gain out of it. He's already been found guilty and sentenced. So it's not going to do him any good to go back to the prosecutor and say, hey, I want a deal, because he's already been sentenced and his sentence was mandatory. There was no other sentence that could be imposed. They didn't seek the death penalty. He was found guilty of first-degree murder. The only possible sentence was life without parole. So it wouldn't do him any good, I don't think. And yes, he would really need to have information that he could back up what he says. On the other hand, I think it could end up helping Donna a great deal. And I think Wendy ought to be darn nervous about the fact that she has created this fracture in the family, because as she moves away from her mom and distances herself from Donna, she and their relationship is kind of fractured. She removes for Donna any incentive, any sort of familial obligation incentive to keep quiet. So if Donna has any information about Wendy being involved in the plot, I think Wendy ought to be pretty nervous about that. And I think it's more likely that Donna, she has way more incentive. For Charlie, I just don't think he has any incentive at this point to do it. It's not as if he can make his life any better by turning. Now, I do want to point out that when Catherine Magbanua, who was Charlie's girlfriend, who was the go-between between Charlie and the gunman, when her first trial ended in a hung jury. After that trial, she then turned on Charlie and the gunman and everybody. Before that, she was staunchly declaring there was no plot, and Charlie wasn't involved. And so she then was able, because she had another trial coming up, she got a new trial because of a hung jury. She was then able to parlay her knowledge into a more favorable sentence. She did, although she did continue to trial, and probably would have fared a lot better if she'd entered a plea. So TXL8Y, thanks, lady. Oh, Texas lady, geez. 817. I'm not good at deciphering license plates either. So Texas lady, 817. I can't find anything regarding Tylee's release. Where is this information coming from, please? It was on the court's docket, and the document was filed yesterday. So one of the things that happens is, if you go to the Idaho cases of interest, they only post the documents that they make available in PDF form. So that document wasn't listed as available in PDF form, but it was filed yesterday in the court's docket. So if you actually click through, search Chad Daybell's name, go all the way to the bottom of, go to his current open case, and then go all the way to the bottom, you will see one of the last entries is a stipulated release of Tylee. So it's there, I promise, and really good news too. Shelly Flowers, how old is the youngest Franke girl? That's a good question, and I am not positive. The girl who was involved in the abuse is 11, but I am not positive she is the youngest child. So somebody else may have the answer to that for us, and so we'll watch for that in the chat. The girl who was victimized and was found in Jody's basement is 11. So Ruby receiving a 12 to 15 year sentence would mean that all of, if she's the youngest, they would all have become adults by then. So good question. I think she is the youngest, but I'm not 100% sure. Hi, Linda. Will they give Jody a plea deal? Yeah, I think they will. I think they will for a variety of reasons. Let's remember, this is Utah. They have seen what has been going on in the Vallow Daybell case, and the fact that the church has gotten kind of a black eye. And Jody Hildebrand has been one of a short number of therapists who have been the top of the referral list that the church provides bishops. So a lot of bishops have referred their parishioners to Jody. One of the things that Jesse Hildebrand said when they gave their interviews was that at one point one of their punishment jobs was to help Jody with her billing, and they said about 80% of the money that Jody was receiving, which, remember, she had a multi-million-dollar home and a lot of assets, she was receiving because her fees were being paid by the compassionate funds that bishops have at their disposal. So each bishop has a pool of money that they can use to benefit their parishioners in those kinds of situations. So if they were to recommend that a person that they were talking with get professional counseling, and they were to refer that person to Jody, and the person said, I don't have the money to pay for therapy, the bishop then could use the compassionate fund to fund that therapy. And what Jesse said was that when they were doing the bills, and Jesse uses they pronouns, and I am trying to get better about respecting that. So what they said was when they were doing Jody Hildebrand's books, about 80% of Jody's income was coming directly from the church, from those kind of compassionate funds. So I think that the church is not going to want that connection to be brought up when it comes to Jody. They would like her to make a deal and go away to prison and not to have a trial where some of that information and the connection to the church is going to come out. So I think, and remember that we are talking about Utah, where many, I won't say that it is as common as, say, Rexburg, but many of the government officials are also church members. So I don't think it's outside the realm of possibility that the prosecutors could fashion a resolution that would still be somewhat better than her going to trial and save the public trial that could reflect poorly on the church. So that's my own spin and my own interpretation. Take that for what you will. I have been researching the church for the better part of a year, reading all of, I can show you my bookcase behind me, which are all the books that I have read having to do with the church. I'll turn my camera just a little bit. And there is my stacks of reading material that I have read mostly last summer, preparing to write the Vallow Daybell books. So that is my take, but it would not surprise me at all for them to offer her a deal, and she would be smart to take it, because I think the outcome of a trial would be much worse for her. So, good question. Hi, Kathleen. Question: with the death penalty still on the table, do you think Chad will take a plea? This is a really good question. If I were Chad's attorney, I would be begging him to take a plea, because that's the only way the death penalty is going to come off the table. I don't know if Chad will take a plea. I think that Chad feels like he wants to be vindicated. I don't think it would be enough for him to plead guilty. I think that he feels like he was victimized and led astray. And unlike Jody Franke, who has been willing to take responsibility and say, Jody Hildebrand manipulated me and led me to do things that I am not proud of, and I am now taking responsibility for. That's not Chad Daybell. So I think if he decides to continue, it will be because he really still views himself as a victim and isn't willing to enter a plea. Now, it may very well be that he's not willing to do that because he has kids who are utterly convinced that he is not guilty. And he does not want to take a plea and remove that belief in him. So I don't know. I certainly, if I were John Pryor, I would be trying to convince him to take a plea, because I think that's the only way the death penalty comes off the table. And I think the prosecutors, knowing that the death penalty came off for Lori Vallow, I think the prosecutors would be willing to take it off for Chad as well. So it will be interesting to see, because the last of those motions challenging the death penalty, the final orders have been filed in those. And so the final word is, you can't get rid of the death penalty. You can't challenge the grand jury, all of the things that he was trying to do to undermine the death penalty. So now that that's been decided, I think Chad should be taking a long, hard look at a plea. So good question. Hi, Alabama. When's the last time you personally talked to Kay and Larry or the Cox family? How was their mindset praying for them? I haven't talked to either one of them in quite a long time. I briefly and occasionally exchange a text or something supportive with Kay and Larry. I exchanged some texts at the time that we heard that JJ's body was going to be released, just telling them I was thinking about them and I was relieved that they were going to be able to find some peace. I think they're in a very difficult position. Now, I will say the Cox family, with the exception of Adam Cox and Rex Connor, who have their own YouTube channel, the Cox family has declined to have any conversations. Summer was quite gracious, but very clear that she was not willing to do interviews or to be involved in any media projects at all. And I think that they have all, since Lori's conviction, have all drawn back and are trying to figure out how to cope and how to deal with it. And they still have an Arizona trial coming up. So, and for many of them, there was more direct involvement in Charles's death, in the text messages flying around and going back and forth, and Adam coming to town to try and do an intervention, and all of those things happening. They were much more directly impacted by Charles's murder. So I haven't had an opportunity to talk in depth with any of them recently, and we just all send our good thoughts and our best wishes for them. So, Lisa Jacobs, ideas on juror number 1 in Maya's case being called in for questioning. The decision was handed down today. Oh, I hadn't seen that. We've seen this in a variety of cases recently, from Murdoch to Adelson. We've seen challenges to jurors. More and more, as jurors are really inundated with media. I mean, nothing happens in the true crime community that people don't hear about it. And true crime is of a tremendous amount of interest, even to local news stations. So it's very difficult for jurors to not be exposed to media. And it is much more common for attorneys to be looking at post-trial. Was there something untoward that happened within the jury? I don't know what will come of this. It really will depend on what the juror says. Now, in the Adelson trial, we heard that the jurors had a group chat that they were in so that they could communicate with one another. That didn't necessarily mean that they were communicating about the trial. They were simply able to communicate with one another about, hey, are you going to lunch, or are you going to be here? Or they were able to communicate with non-trial information among themselves. When Charlie Adelson's attorney brought that up to the judge then said, I want to see that group chat. The jurors provided the judge with the group chat information and made it available to the court. The court went through it and said, well, there's nothing untoward in here. There's no discussion of the case. There's no suggestion that anything improper happened. Now, in the Murdoch case, his attorneys have filed for a new trial based on the fact that they believe that the clerk of the court had some kind of influence on the jury. And there are a number of issues going on in Murdoch, and that will be a discussion for the next time we get together in January, because those challenges to the jury and ethics violation charges for the clerk of the court are going to be pending a while. So we'll have a while to chat about those. But I don't know at this point that we know anything about whether or not that juror did anything untoward. It's just not at all uncommon these days to have juries challenged or to have jurors questioned. Hi, Carol Renner. Normal people kill. So for me, how can both the insane and normal commit the same crime with different consequences as prison or psychiatric hospital? So this is a good question. Our law says that you can only be held responsible for a crime if you are doing it knowingly or intentionally. You have to have established the mental state that goes along with the crime. So if a person can form the intent to commit the crime, we say that they have done that crime knowingly or intelligently or intentionally or any of those sort of typical mental states. If, on the other hand, a person does not have the ability to form the mental state to commit the crime, if they commit the crime, we say that they cannot be held culpable. So this is very different from whether or not a person is competent at the time that they stand trial. Now, we've had this conversation a number of times. Whether or not someone is able to form the mental state to commit the crime is one question. The other question is whether at the time of trial, the person understands the charges against them and can aid and assist their counsel in conducting their trial. So if a person like Jeremy Best, there is a question about whether or not he was sane at the time he committed the crime, that's a different question than whether or not he can be restored to competency to stand trial during a trial. In Jeremy Best's case, there is substantial information that would indicate that he was insane at the time that he committed the crime, that he may not have had the ability to form the mental state to commit the crime. That's the definition of someone being insane and so not culpable. Generally, what happens if someone is declared to be insane, they're committed until the time that they are restored to sanity. And then the state will have to decide whether or not at the time that the crime was committed, whether they were sane or not. I think in Jeremy Best's case, it is very likely that he will be found to have been not competent at the time the crime was committed. The crime is heinous. There is absolutely no argument about that. But our system only holds people responsible if they had the ability to form the intent to commit the crime. So that is the reason why we have people who, as you say, normal people who commit murder. And more likely that and I want to remind people that the legal definition for what would be an excuse, I don't want to I use that in legal term, would be a legal defense or a legal excuse. The definition of that insanity is very narrow. It's not enough to have a personality disorder or to be a narcissist or any of those things that we saw with Lori Vallow. You have to be so removed from reality that you do not have the ability to form the mental state. Now, Lori Vallow is has narcissistic personality disorder. She has religious delusions, but it's very clear from the facts of the case that she was more than able to form the mental state to commit the crime, even if Idaho allowed a defense of insanity, which Idaho does not. But in states where the insanity defense is permitted, which is all but 4, in those circumstances, you still have to be able to prove that the person was so insane that they could not form the mental state. And that is a far cry from somebody who has a narcissistic personality disorder or even religious delusions. So, good question. Hopefully I answered it. If I didn't, please let me know. Hi, silly me. Question, who is getting Tylee's remains? I don't know that yet. My understanding from some of my conversations was Larry and Kay had been talking to the Cox family, and they were very much in hopes that they could lay the children to rest together, because Tylee and JJ were so very close, and Tylee was really like a second mom to JJ. So I think that I'm sure that that's still their intention. That is kind of a private matter that'll be dealt with between the families. And I am certain that at some point, the families will let us know. So, is the book going to cover the church and their responsibility in the case? Absolutely. I believe that Lori and Chad's belief system was rooted in their upbringing in the church. And there are a couple of very in-depth chapters about the specifics and about some of the changes that are going on in the church that that go far beyond just Chad and Lori. So it was a very much interest to me in my attempting to understand the big picture. And so I have done everything that I know how to be respectful of the church and to recognize that that for the most part, our LDS neighbors are wonderful, kind, warm, loving people, generous to a fault, and raise lovely families. And there is a very small sector of the church who really are being identified as neo-fundamentalists, some people calling them Deseret fundamentalists, Deseret nationalists. These are folks who really want to take the church, which has made huge social strides, back to the days of Joseph Smith. So the book does go into that, does look at the history of the church, and then in order to be able to look at the ways that those factions within the church are trying to take the church back into the 1800s. So these are great questions. I'm so excited. I'm very proud of the book, and I'm really excited that you all are finally going to get a chance to read it. And then I hope that you will appreciate the amount of research and time and work that's gone into it, because it really does tell a broad story. Hi, Janice Green. Do we know if Donna is still in observation? I don't know. I had seen somewhere in one of the chats that someone reported that she had been moved out of observation, but I don't know that for sure. And actually, one of the YouTube channels I watched today was still talking about her being in observation. So I'm not positive. It is a bit unusual for someone to stay in observation as long as Donna has been, but then I kind of understand it when you actually have somebody who apparently was preparing and had a plan, that they would be cautious before they would be letting her have headphones for her iPad and, you know, those sorts of things. They're going to be careful. So, hi, Beth, bringing back. Will your book address the religious aspects of the Vallow Daybell case? I'm interested in what part her hyper-religion played. Absolutely. As I was just saying, I have spent a lot of time looking at church doctrine, how it has evolved over the years, and how Lori and Chad's LDS beliefs played into some of the things that they believe. It is important to know that these are doctrines that the church has abandoned and moved away from, and Lori and Chad were clearly part of a group who has endeavored to move the church back to those less enlightened views on people of color, on polygamy, on a number of issues within the church. And so it's important to understand that this is a faction of the church, many of them who are still active members who are attending church every day or every Sunday, people who are still holding church callings, but are part of this neo-fundamentalist factions that really want to take the church back to the doctrine from the time of Joseph Smith, and to kind of undo some of the more progressive moves that the church has made. They want to undo some of the more progressive moves the church has made having to do with women and the role that women hold in the church. So it has been very enlightening and interesting for me to delve into that piece. And but I felt that it was important because I felt that it was important to understand Lori and Chad's motivation, that what was motivating them, apart from Lori's mental illness, what played into that and was motivating them was this desire to go back to ancient doctrine. Hi, Janet. As far as I know, there will be an audio version that is up to my publisher, but it is part of my contract, and I believe there will be an audio version. It's a little bit unusual for authors to narrate their own books, unless they happen to be people like Elizabeth Gilbert, who has the most amazing voice in the world, or they are well-known authors who people know their voices. My last book, my divorce book, was voiced by somebody else, and I haven't been approached by the publisher about whether or not they would like me to voice my book. I'm not attached to narrating it. I do this and I talk to you one-on-one, but I don't know that I have the best book reading voice. And so I'd be happy to have somebody who is much more adept at it do it. And but I'm certain that it will be out in audiobook at some point. So, and I'll be excited for that part too. Hi, Silly Me. When is pre-sale? So here's the plan. And I'm going to have a lot more about this once some of the pieces come together. The plan is to launch pre-sales in Nashville at CRIMECON the last weekend in May. So we're going to have a booth. We're going to be handing out swag and extra goodies to folks who can show us a pre-order. And once we do that kickoff launch, then we'll be doing the same for folks who pre-order through the website. So it's going to be really exciting, and you should look for a lot more information about it. The other thing we are going to work on after the first of the year is another quilting project. For those of you who might not have been here at the very beginning, the True Crime quilt was won in the raffle by Kathy Watson. And so Kathy, if you are here tonight, drop us a comment in the chat or DM us, and I will get us I will get the quilt off to you as soon as possible. If Kathy's not here in the chat, we'll contact you by email and get in touch with you to get the quilt to you. And we are going to be doing another quilt along. It is going to be where everyone makes a square. When you send them in, we're going to put them all together and make a quilt for Larry and Kay. It'll be a memory quilt. So that will be a folded, it will look like a Japanese folded crane. Still working on getting permission for the pattern, but if I don't get it, I will be coming up with a pattern myself. Hi, Linda Sears. Will you still join us for a weekly chat once you're famous? Oh, heck yeah. I'd miss you too much if I didn't. So absolutely. I'm not going anywhere. I'm already noodling the idea of a new project, and we'll have more on that coming up. But for the next little while until May, I'm going to be laser focused on the launch of the book and the promotion for that. So we'll be doing marketing and promotion for that, and you'll see a lot more. You'll probably see that book cover until you're sick of it. So, so thanks for asking. Glowing Ember. Question. Franke Kid's treatment reminds me of Shanda Vander Ark case. Have you or will you look into it? You know, it may have been you, Glowing Ember, but somebody did ask me about that case, and I had it in my notes, and I didn't because I felt like I had so much to talk about today, but I am making myself another note. So next time we can look at it. One of the cases that I have found really interesting, you know, you follow enough of these cases and you begin to see parallels. The one that I found interesting is the parallel between the Piketon Piketon, Ohio case with the Wagners and the Adelson case, having two domineering grandmothers who wanted to be in control of their grandkids. So, but I will look into the Shanda Vander Ark case, and we can talk about it when we get back together in January. So great question. And I'm not going anywhere, so you're stuck with me. Bard B. If the state offers Chad a plea, do you think they will require him to give details about what happened, or will they let him say guilty and sit down? So when a defendant enters a plea, they're always advised that they will likely have to talk about their crimes. However, they're limited to a general description of their crimes. They're not required to make a detailed allocution of their crimes. Now, that doesn't mean that they may not be required to sit down with law enforcement and the prosecutor and have a conversation. Because up to this point, as far as we know, Chad has refused to talk to law enforcement. He has invoked his right to remain silent, and he has not spoken to law enforcement. So it's likely law enforcement would want to sit down with him, and there may be further details, and that may be information that would be that the victims would find valuable, information that would help put their minds at ease or would help answer their questions. But it likely would not be information that would be made public. The public would likely get a recitation of the facts, and it would be very general. So we saw a recitation of facts in Ruby Franke's case. She did admit that she had abused her children, and that she had abused her children in some specific ways that had caused them injury. That was about as detailed as you're ever going to get in a plea agreement. That, like I say, that doesn't mean that Chad wouldn't sit down with law enforcement or with the prosecutors and give them a more detailed description of what happened so that they could help pass that information on to the families. I kind of doubt that Chad would do that, because I don't think that he ever wants his own children to have that information. So I think we probably will see something that looks much more like, I did it, I'm going to give you the very most superficial information I can and sit down. Hi, Squeaky Wheel. Question. Judge Boyce shot Chad down on removing the death penalty. What can John Pryor do now that he isn't death penalty qualified? Second seat, who pays the tab? This is a good question. So the issue of whether or not someone is death penalty qualified really is only an issue if they are court appointed, they are state appointed and paid for by the state. So let's remember that John Pryor was retained by Chad Daybell. He was paid some amount of money, which we don't know. We know that when Chad Daybell came back from Hawaii, he had about $135,000 or $138,000. That money went to support a number of things, including the initial lawyers for Lori, his lawyers, probably a lot of other things as well, like just living expenses. After he was arrested and it was clear that they had run through that money, he deeded his home to John Pryor. We do not know what the plea arrangement is, or the fee arrangement is with John Pryor. That has never been made public, and attorney fee agreements usually aren't. That's between John Pryor and Chad. But at this point, Chad has never said he was indigent, and he has never asked for court-appointed counsel. So John Pryor is continuing as a retained lawyer. Now, when a person retains a lawyer, it is their responsibility to determine whether that lawyer is qualified to represent them or not. So whether Chad is qualified, whether or not whether Pryor is qualified, whether Chad has confidence in his abilities, that is all between Pryor and Chad. If, on the other hand, Chad were to say, I no longer have any money and I can't afford a trial, and so I want a court-appointed lawyer, the state would require that any lawyer who represented him met their minimum qualifications to serve as a death penalty attorney. And in general, that means that they have to have already had experience on death penalty cases, at a minimum have to have sat on a number of death penalty cases as second chair. But that is not a requirement as long as Chad's counsel is retained. So the fact that the death penalty remains on the table is not going to disqualify John Pryor. Now, here's what I have observed about John Pryor. The motions he's been filing, some of the folks that were in court with him at Lori Vallow's trial. He was at Lori Vallow's trial a lot and had a whole team with him. He's got a mitigation specialist, he's got an investigator, and I think that he is at least consulting with somebody who is an experienced death penalty attorney. He's filing all the right motions. He's doing all the right stuff. So I think he's getting advice from somebody who is more experienced. But what our ethical guidelines say are not that you have to be an expert at everything, but that you have to make yourself competent in a particular area or issue to represent a client. So Chad does have the ability to educate himself and work hard and research and be able to feel confident that he is able to sufficiently represent Chad. So that's a really good question. I want to point out we have a lovely little Christmas message from Michelle. Michelle's been a little under the weather tonight, which is why Jen so graciously offered to join us and moderate for us. And we appreciate her help no end. Michelle is really at that point in her chemo where it's up and down, and sometimes as much as minute by minute, you know. Sometimes she'll feel pretty good, and then all of a sudden she doesn't feel so good. So please send her all your love and prayer, and because I know that she appreciates it, covets your prayer, and your good wishes. So, well, folks, we are coming up. Oh, I'll get to that one. We are coming up on the very end of our 2 hours, so I think this will be the last question. If you have questions we didn't get to, please post them in our chat. I do read the chat and I do answer them. I've been a little bit slower to go through the chat every week and to read the comments, only because I have been up to my eyebrows in book, but I'm feeling pretty confident that we're at the end part of that. So please post any questions that you have in the chat. If you don't feel comfortable doing that, or if it's something that you want to ask me privately, feel free to email me as well. So what's going on in the Delphi case? Well, what is going on in the Delphi case is that on the 18th of January, the Supreme Court, the Indiana Supreme Court, is going to hear the argument on the issue of reinstating Baldwin and Rosie, the attorneys that for Richard Allen that Judge Gull removed. So the judge in the case, Judge Fran Gull, removed Rosie and Baldwin, saying that they were grossly incompetent because there had been a leak of trial photos or crime scene photos from Baldwin's office, because a person who had access to his office, unbeknownst to him, took a photograph of them and then sent those photos out to some web creators, to YouTube creators. So fortunately, those creators immediately reported it, and the leak was staunched without it being too widely distributed. But judge said that that was grossly incompetent and dismissed them from the case, appointed new lawyers, and set the trial out that was set to start in January. Now, Baldwin and Rosie said they were ready to go to trial in January, and Richard Allen very much wanted that trial to go forward. He wants Baldwin and Rosie back on the case. So Baldwin and Rosie filed a motion with the Indiana Supreme Court. They had to get over a couple of procedural hurdles, which they did. And the Indiana Supreme Court has agreed to hear the oral arguments on the case, on their motions to reinstate and to disqualify Judge Gull on the 18th of January. So I'm excited to hear what's going to happen there. I'm pleasantly surprised that the Indiana Supreme Court agreed to hear the issue and that they agreed to hear oral arguments. There are quite a few people who have filed amicus briefs, different groups who have filed in support of Richard Allen and in support of Baldwin and Rosie. So, I'm cautiously optimistic that we may see a good result in mid-January. Until then, it's just kind of in a holding pattern. So, great question. I want to thank everybody, not only for tonight, but for this whole year. I want to thank you all for being devoted, for sticking with us, for following in the chat, for being patient when we don't get things done as quickly as we'd like to because there's so much on my plate. And thanks so much for all of your generous donations for Michelle. I appreciate every one of you. I love our community. I love our chat. I'm incredibly grateful to all of you for being part of this and sticking with me as we go through this. I want to wish you all the merriest of Christmases and Happy New Year. And I will see you next year. Be safe, be happy. And I hope that you have as many things to be grateful for this year and in the coming year as I do.